enter a plea of guilty or nolo. You may wish to enter a plea of not guilty, and while you prepare for trial, you can also look up that information. All right, DeMarcus Cantrell Brown.
Your Honor, we were representing him, but we are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay, aka Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
I not right now. I'm seeking counsel.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time...
Buckle up, guys. Today we're going to watch a courtroom clash where confidence collides with reality. The defendant opens by leaning into sovereign citizen language, asking for delays and questioning authority, clearly believing the script will carry him. From the jump, the judge signals patience but not tolerance, making it clear this court runs on rules, not internet theories. This opening frames the power struggle perfectly and sets the stage for everything unraveling next.
You need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right? Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness, okay?
Okay, I got you.
All right. Anything else?
All right, guys, this is where the wheels start to wobble. The defendant fires off claims about jurisdiction, affidavits, and imagined rights, expecting magic words to shut the case down. Instead, the judge calmly explains personal and subject matter jurisdiction, dismantling each argument piece by piece. From a third-party view, you can see the imbalance clearly. One side relies on myths, the other on law, and the courtroom momentum shifts fast.
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something. Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have...
Wait. You see this book right here?
Uh-huh.
This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, It's
I got
not
books.
that way.
Can I show you my Black Law Dictionary?
No,
about
sir.
private property?
Because Black's
And
law,
prove it?
that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So
All
you
right?
say it's not a difference between public and private for the record. There's no
No,
difference.
sir.
All right, guys, this part is the turning point. The judge stops entertaining theory and starts educating. She explains her role, her authority, and where the law actually comes from, drawing a clear line between real statutes and online fantasy. The defendant listens but doesn't absorb it, still clinging to his script. From the outside, it's obvious this moment seals his fate. The court has moved from discussion mode into control mode.
Sir,
So you're telling me
get
I'm
an
not trying to
attorney.
have. Okay, all right.
Thank
January
you.
5th.
Yes, sir.
Okay.
And Mr. Bay/Brown,
Bay.
you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you telling me United States codes don't work?
No, I'm telling you, you don't know them.
Got him.
So
I
first
have
of
it
all,
right here.
the United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes,
So
sir.
according to 49.
Mr. Bay, Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m.
Alright, so that's the end of his first appearance. Now let's get to the spicy bits, where he brings on his attorney, who also happens to be an attorney general. And, oh yeah, his lawyer also thought it was a good idea to bring a gun and sword into the Zoom court hearing. Let's call this segment How a Not Attorney Fucked His Not Client's Case Up.
So, DeMarcus Contrell Brown,
I have interest in that matter. It's the defendant in error free to go.
if the who, what?
It's the defendant in error free to go.
No.
Well, let the record show the defendant in error is ordered to state and participate.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir? 'Cause I
Attorney
have-
General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on, let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Sir,
a notice of
Mr.
acceptance
Bay.
of the oath of office.
Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr.
Hell no.
Attorney, Mr. Bay, hush. Mr. Attorney General,
I'm trying to
are
set a
you
record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off me.
What's going on is he's a member of a foreign state corporation basically doing business in Georgia. So
Okay, sir,
basically,
that's
going
not
to
what I
Georgia,
asked
all
you.
places-
No, sir.
I get what you're saying,
No, sir.
man.
No, and I get what you're saying, but we're not doing
I
that
know,
because
I know.
that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you
We
on
understand the rules of the court. We understand the rules of the court. I got you.
Okay, are you a member of the State Bar of Georgia?
No, I'm not a member of the bar of Georgia.
Okay,
What
then-
I'm trying to
No, then
realize
as,
he's doing
then,
Buckle up, guys, because this is where things go from misguided to absurd. The defendant introduces a supposed legal representative who turns out not to be licensed or recognized in any meaningful way. The judge questions credentials, exposes the gaps, and shuts the whole performance down cleanly. Watching this unfold, it's clear the court isn't confused at all. The only confusion lives on the defense side, and it's costing them credibility by the second.
as
way
he
in
can
Georgia,
represent
and that you need to
himself,
take consideration on that matter on how he's doing
can
business in Georgia.
he can represent himself, or he can be represented by a member of the State Bar of Georgia. But he cannot have you represent him or purport to represent him, okay? That's not gonna work. All right, so Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I
would,
plead to be released.
that would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object. You cannot practice law from the bench. Violate
put you on
180
a-
USC 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at
I
trial.
object.
All right, sir. Thank you. You'll get notice in the mail if anything
I
changes
object.
about your if anything changes about your address, then you can go ahead and let us know by coming
I
into.
have no. I demand an evidence hearing.
You will have that at the time
I
of the
demand
trial,
an evidence
sir.
hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
You
a
are
resolution.
dishonorable. I got your oath, Tammy Long. Hey,
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the
you
mail.
in violation of Article 6,
And
Section 2 of
once
the
you
Constitution.
get, your notice in the mail, then you can appear for hearing with whatever evidence that you wish to
I
present.
object.
Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time.
I object.
All right, Kevin Jermaine Burrows.
All right, guys, this is the conclusion where consequences replace conversation. The defendant invokes silence, forcing the judge to enter a plea on his behalf and formally move the case toward trial. From a third-person perspective, this is the final confirmation that the sovereign script failed completely. Procedure wins, order is restored, and the case moves forward. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.